Liberty Nation. Truth is making a comeback.
Hi, this is Tim Donner with LNTV. A Supreme Court decision about arbitration. Doesn't sound very big or exciting, but that's why we brought on LibertyNation.com legal affairs editor Scott Cosenza to explain why it really does matter. So, Scott, tell us about this case and why we should care about it.
Well, you should care about it, and why the world cares about it, legally speaking, is that it affects millions of people's employment and many, many, many millions, if not billions of dollars. This case involves whether or not people who take a job and then agree when they take that job to settle any claims against their employer in arbitration rather than in the courts, whether or not that's legal, essentially. There was a law called the National Labor Relations Act, and I think it was 1935 is when that was passed. And 10 years prior, there was something called the Federal Arbitration Act. And the Federal Arbitration Act basically said that they're going to honor arbitration agreements. And when the National Labor Relations Act was passed, that guaranteed a right to basically sort of collective bargaining, working with your fellow workers to better the workplace environment and negotiate against your employers for same. No one at the time that the National Labor Relations Act was passed believed that it superseded or voided the provisions of the Federal Arbitration Act that allowed for arbitration agreements. Those were not very common at the time. Factory workers in 1932 didn't sign arbitration agreements usually when they got a job. So this wasn't a thing there. And in fact, until I think it was 2010 or 11, even the Obama administration didn't think that it did. But somebody had the bright idea that, and I'm going to guess, unfortunately, it was probably a brother member of the bar, sister member of the bar, who saw some gold there. So if you can get into the courts as a class action as an attorney, it's a gold mine. We all see these cases where there's class action settlements and the attorneys make out like bandits and everybody else maybe okay, maybe not. But that's what this case is about attempting to get access to the courts for these people, Tim, who have already signed arbitration agreements. And those arbitration agreements are in place largely because the courts have failed the employers in terms of acting efficiently and fairly in their mind. So they don't want to spend a year in court over some issue where it can be settled according to arbitration principles. And that's what the case was about. It was a 5-4 decision. Justice Gorsuch wrote the majority decision. He was joined by the Chief Justice, by Clarence Thomas, Judge Alito, and I think Judge Kennedy, and Judge Ginsburg wrote for the dissent, and she was joined by Sotomayor and Kagan and Breyer. So it was a contentious decision. You know, earlier on the Uprising podcast last week, Tim, we talked briefly about whether this was an ideological kind of divided court or not. And I can tell you that the gloves are now off, judicially speaking. This is fairly intense, with Justice Gorsuch addressing defense issues in the opinion itself, and with Justice Ginsburg reading from her dissent from the bench, which is not typically done. And it goes to the level of passion, I think, with which these various sides hold their cause.
As you write in your piece, elections have consequences, and the fact that Donald Trump was elected and appointed Neil Gorsuch almost certainly resulted in a different decision than we would have had if Hillary Clinton was elected president and appointed or nominated a leftist to the court. But this really amounts to a victory for contract law, doesn't it, Scott? To the viability, the necessity to have unviolable contract law?
I see it as a victory for contract law, Tim. That's exactly right. The ability, you know, we're talking about people who agree before they take a job to go through arbitration to settle their disputes. That's all this is about. And it's not like the arbitration is conducted by the factory owner's brother in like a shed behind the factory. I mean, we're talking about, regular, normal arbitration that, almost all businesses would require to deal with other businesses. So it's not even that the people are in lesser bargaining positions, even though they are. But I think that you and I and probably others on our side of the aisle would suggest that if you're not happy with the terms of your employment, you should seek other employment. You shouldn't years later sue your former employer in federal court and argue that they owed you for some hours, even though you both agreed at the time that you weren't entitled to that pay. And that's sort of what happens here. So I do think you're right. I think it's a free contracts case, and that's why I think that it was so sharply divided. The majority, Tim, majority opinion is not full of ambiguity. Justice Gorsuch and his signatories to that opinion see no way that the law could be anything other than there's no new right that's been discovered after 70 years of a piece of legislation being in place. But that is the divide today. We have people who believe that new things can be discovered, like gay marriage. Not only does it exist now, but it was constitutional the moment the Constitution was ratified. I mean, that's the official position of the United States Supreme Court, is that it always was legal. So it seems a little,
You're talking about emanations and penumbras and things that sort of radiate from the Constitution that we weren't previously aware of. This is a very slippery slope, this idea of newly discovered rights that we've discovered now, 250 years after the Constitution was written. I mean, it's somewhat akin to Roe versus Wade, is it not, where the Supreme Court discovered the right to have an abortion as a newly discovered right that hadn't previously been discovered for 200 years.
I think that there may be a distinction there with respect to abortion, because I don't think it was even contemplated that, the surgical abortion or medical abortion at the time of the founding. But contracts and arbitration contracts specifically were certainly contemplated in 1935, because it was the 1925 Act that gave federal enforcement power to those agreements. So the Congress in 1935 clearly knew that the FAA, or the Federal Arbitration Act, was in place. And if they wanted to significantly restrict or revoke that, they could and should have done so explicitly. Nobody thought so. Nobody argued so until 6 years ago. It's, from 1935 until now, that's the scope of this new and invented right that I think, if I can editorialize, fortunately for sure, Gorsuch is on the court, and they struck down.
So, Scott, obviously you're a lawyer, constitutional lawyer. So let me ask you a question. You're talking about two different acts of Congress from the 1920s and 1930s. We're talking about 80, 90 years ago. Well, why are we just getting around to figuring out what they mean now?
Well, that's the thing, Tim. Some clever lawyers thought they could make a buck, I think. That's not something that was issued in the official opinion, but that's one man's opinion anyway.
There's a first time for everything, Scott.
Yes.
Thank you, and you can read more of Scott's fine work on all matters legal and illegal on LibertyNation.com. I'm Tim Donner, and this is LNTV.
Liberty Nation. News and commentary, minus the propaganda. LibertyNation.com.